Mr. Perkins, who do you have, counsel?
I have Jamar Owens, and this Tushar is the prosecutor is handling not only him but a couple other individuals too.
Thank you. Good afternoon, Madam Prosecutor.
It's 4 defendants on that one file, but they said only 2 was going.
Okay.
They said they wasn't sure about the other 2.
Okay.
So further on number 2.
Okay, thank you. So, Madam Prosecutor, I was been informed by the Madam Clerk that are you speaking of the four co-defendants?
Yes.
I believe that Mr. Perkins so it appears that 2 of the 4 are going this afternoon.
Yes, Your Honor.
Okay. And are they both males?
One's a male and one's a female, and they should both be in Division 3.
And you have Jamar Owens, is that correct, counsel?
Jamar Owens and Krista Amerson, Your Honor.
Yes.
Thank you. And so, DDC, if you could bring Jamar Owens first. Counsel and Madam Prosecutor are here on Jamar Owens.
County Jail.
He's at Dickerson. He's at Division 3.
Thank you all. Nope. That's fine. I see that now. So we'll have them call us up right now, and then we'll handle these as soon as they call in. Okay, counsel?
Thank you.
All right. Thank you, Your Honor.
Thank you both. Thank you. So if we could have them both, that'd be great. How you doing, officer?
What's going on, Mr. Craig? You all right?
I'm well. How was your holiday, sir?
It was wonderful. How about yours?
It was wonderful. Thank you for asking. You're looking good. You're looking slim. You didn't eat too much. I can tell.
I'm trying to cut back.
You look at your pleasure, sir. I believe we have the files ready, so bring them at your pleasure. We may have to break when Division 3 comes in for the reasons just stated, but otherwise we should be ready to go.
Okay, let me know which ones you have, sir.
All of them, I think.
We have the files. The attorneys are not in the courtroom, and Madam Clerk is going to get them right now. She's ahead of us. And so as soon as they come in, we can let you know who they've interviewed if you don't know, and we can bring them out however you want after that.
Understood.
Thank you. And then we have another one too in Livingston. 3. Okay. Do you know if we'll figure that out. 3. Thank you. Gosh, you're the best. Thank you.
DDC 500 Jones. That don't be nothing to do.
That's the fine. Let me get a copy of that.
Thank you. Thank you. The viewing was. That's in Livingston.
Yeah.
Good afternoon, counsel. Okay, officer, counsel is present. You want to let the officer know who you've interviewed, sir? Or who's ready to go? If you want to yell it out to him, he's ready to take it down. What's happening, Green?
Hey, brother, who you got ready, man?
I got Brown ready. Number 3.
That's it?
Guthrie, Andrew Sanders. Number 9, number 3, and who was the other one? And number 2. Oh, that's a female. Edward Menson. Number 5, Menson. Jalen Thomas. And David Thomas. Jalen, I apologize. Jalen Thomas. Number 4.
Guthrie is a female, so remember straight down with the guys.
Appreciate you, officer. Thank you, as always. And then, Brother Counsel, it appears on number 12 and 13, 12 has retained counsel, Mr. Perkins. Number 13, they're both at Division 3. Do you know if you've had an opportunity to interview number 13? It does that. Okay. Awesome.
Magistrate, please.
Yeah. Yes, sir.
Can you let counsel know that I also have Todd and folks ready to be interviewed, please?
Todd and folks are both ready to interview. Thank you. Copy. Brother Counsel, did you hear that, sir? He said, I guess, number 11 and 14 and 15 are ready to interview. Okay. Good afternoon, sir. Your name? Oh, go ahead. Go ahead.
My name is Christopher Brown.
Good afternoon, Mr. Brown. One moment, sir. Your attorney is grabbing some information. And Madam Prosecutor and Counsel Perkins, we're still trying to reach Division 3, and as soon as we do, we'll call your matter. One moment, Mr. Brown. No worries. Thank you for your patience, Mr. Brown. Could you state your name one more time, sir?
Yeah, my name is Christopher Brown.
Okay, this is Division 3 calling in right now. Thank you, Mr. Brown. And good afternoon, Division 3. Just give us one moment. We'll handle your matters as soon as we finish this gentleman, okay?
Okay.
Thank you. This is case Mr. Christopher Brown, 200-62195, People State of Michigan versus Christopher Brown. Appearance, please.
Yeah, now, I'm Christopher Brown. I'm trying to waive his right to formal reading. I understand the constitutional right to stand mute.
Thank you, counsel. Court, waive formal reading in there, please. Not guilty. Thank you. And the court scheduling a probable cause hearing. Mr. Brown, you must attend January the 6th, 2021. 8:30 a.m. 36th District Court in front of Judge King. Mr. Brown, that hearing will take place via Zoom, which is an off-site streaming technology. You'll get information on how to connect before you're released, but it's your responsibility to connect on time. Is that understood, Mr. Brown?
Yes, sir.
Not guilty is under Esteban.
What kind of indicates to is that he is, he's going to be a lifetime resident in Detroit. He also indicates that he has no prior criminal conviction. He's employed with a long service company, high school graduate, not on probation for Royal Young. All those serious non-assault allegations.
Thank you, Brother Counsel. Mr. Brown, the court takes consideration a number of things upon imposition of bond. The information provided by your counsel who's advocated well on your behalf, as always. This is a very serious allegation, sir, but it is non-assaultive. You appear to have ties to the community, no prior convictions or capious history of the court's aware of. The court takes into consideration the current epidemic facing the nation as well as the allegations set forth in the investigator's report. During this bond, Mr. Brown, you are not to purchase or possess a firearm or any dangerous weapon. Is that understood?
Yes, sir.
And for that reason, sir, you'll be released on a $7,500 personal bond. Good luck, Mr. Brown. I hope it works out well for you, sir. Where happened to Division 3?
White line, first and last name. White line, first and last name. Face mask on the nose and mouth. Yes, sir.
Jalen Thomas.
What? Thank you. And where did Division 3 go? Yeah, could you call them back? One second, Mr. Thomas.
Okay.
Councils, it appears that Division 3 has dropped their connection, so as soon as they call back, we'll take care of your arraignment. I apologize. Court officer's calling them back right now. And your full name again, Mr. Thomas?
Jalen Thomas.
Thank you. Sir, you're here for 200-62197, People State of Michigan versus Jalen Edward Thomas. Counsel.
Yes, Your Honor. Right word, we have Jalen Thomas, my client waives the right to formal reading, understands the constitutional rights, understand you.
Court waive formal reading on their plea of not guilty. Mr. Thomas, the court scheduling a probable cause conference. Sir, you must attend January the 6th, 2021, 8:30 a.m., 36th District Court in front of Judge Giles. That hearing, sir, will take place via Zoom. That's an off-site streaming technology. You'll get information on how to connect before you're released, but it's your responsibility to connect on time for that Zoom hearing. Is that understood, Mr. Thomas?
Yes, it is.
Thank you, sir. Not guilty is under Esteban.
Testifying, Your Honor, my client case is he's a 19-year-old lifetime resident in Florida County. He also indicates that he has no prior criminal conviction.
We got him, officer. They can come back in. Sorry. I apologize. Okay, officer, as soon as we handle this arraignment, we're going to take care of your matters in Division 3, so don't hang up, okay?
Okay, all right.
All right, thank you. I appreciate you. Just give us a couple minutes. I apologize, counsel.
No problem. High school graduate, Your Honor. I just start off. No prior criminal conviction. He has no prior criminal conviction. Works at the factory called U.S. Paradigm. High school graduate, not on probation or parole. Although serious, Your Honor, it's a non-assault allegation.
Thank you, brother counsel. Mr. Thomas, this is a very serious felony allegation, sir, but it is non-assaultive. The court considers the lack of capious history or criminal convictions the court's aware of. The information provided by counsel, including but not limited to your ties to the community, your employment status as it relates to ability to post bond, and the court's read and considered the information alleged in the investigator's report, as well as take into consideration the current epidemic facing our nation. Mr. Thomas, during this bond, sir, you are not to purchase or possess a firearm or any dangerous weapon. Is that understood?
Yes, it is.
And Mr. Thomas, for those reasons, sir, you'll be released on a $7,000 personal bond. Make sure and listen to the court, sir. Good luck.
Okay, you too. Have a nice day.
Thank you. I appreciate that. And DDC, if you could give us a moment, we're going to handle some matters with councils present. Okay. As soon as Mr. Perkins gets here.
I just want to try to on here and he ain't have no hoes. So traffic, no hoes in the first.
Okay. Thank you, Officer Division 3. Who do you have in front of you, sir?
Who here?
Is that Jamar Owens? Okay, you muted yourself, Division 3. You're on. Oh, there. Thank you. Appreciate it. Good afternoon, sir. Could you state your name, please?
Jamar Londell Owens.
Thank you, and good afternoon, Mr. Owens. Sir, you're here for case number 200-62062, People State of Michigan versus Jamar Londell Owens, identified in the complaint as defendant 2. Counsel's your appearance.
Good afternoon, Your Honor. Erica Tusar on behalf of the people.
Good afternoon, Your Honor. Good afternoon to your staff. May it please this honorable court. My name is Todd Russell Perkins, P55623, appearing on behalf of Mr. Owens. We waive any formal reading of the warrant and complaint in this matter. I respectfully ask the court to enter a not guilty plea at this time. I stand on mute.
Good afternoon.
Yes, the court to enter not guilty.
Thank you again, and good afternoon, brother counsel. Court waive formal reading under plea of not guilty. We'll get to the court dates in a moment. As to bond.
People have no objection to a personal bond, Your Honor.
Thank you, Madam Prosecutor. Brother counsel.
Well, I guess just very simple. My client is self-surrendered in this matter, intends to defend in this matter, and I'd ask the court to grant him a recognizance bond.
Thank you, counsel. Mr. Owens, the court takes into consideration a number of things upon imposition of bond. Your attorney's information is provided, as well as the nature of these charges, the facts that have been presented by your counsel that you surrendered yourself to authorities. These are serious allegations, Mr. Owens, but they are non-assaultive. The court considers it lack of capious history or criminal convictions. The court's aware of, given the information alleged investigators report, the current epidemic facing the nation. Bond on this matter will be set in the amount $10,000 personal bond. Anything further, counsel?
No, Your Honor, the dates.
Oh, thank you. That'd be important. Okay, the court's scheduling a probable cause conference January the 6th, which is 2021. That's at 8:30 a.m., 36th District Court in front of Judge Giles. And that hearing will take place via Zoom.
Via Zoom. Is that 5th or 6th, Your Honor? I couldn't hear you.
6. Thank you. 6. 6.
Okay.
Okay, January 6th, 2021, in front of Judge Giles at the 36th District Court, and that will take place via Zoom. Mr. Owens, it's your responsibility to connect on time. Good luck, counsel. Good luck, Mr. Owens. Anything further, sir?
No, Your Honor. Thank you very much.
You're welcome. Have a nice day and be safe.
All right. Thank you.
Good luck, Mr. Owens.
Thank you, sir.
And then, do you have a Amerson ready? Thank you. One moment. Could you state your name, ma'am? Good afternoon, Miss Amerson. You're here for case 2006206, People State of Michigan versus Christina Monica Amerson, identified in the complaint as defendant 4. Brother counsel.
Yes, John Brandenburg, on behalf of Christina Amerson, my client, waive the right to formal reading, understand the constitutional right to stand reading.
Court waive formal reading in her plea of not guilty. The court, Ms. Amerson, scheduling a probable cause conference. You must attend January the 6th, 8:30 a.m., 36th District Court in front of Judge Giles. That hearing, Ms. Amerson, will take place via Zoom, which is an off-site streaming technology. You'll get information on how to connect for the Zoom hearing, but Ms. Amerson, it's your responsibility to connect on time. Do you understand? Yes?
Yes, sir.
Thank you, ma'am. Not guilty is entered. Anything as to bond from the people?
People have no objection to personal bond, Your Honor.
Thank you, Madam Prosecutor, Counsel.
49-year-old, no prior criminal conviction, John, 49 employed at the post office, not on probation for parole. It's a non-assault allegation, respectfully ask for personal bond.
Thank you. Ms. Amerson, these are very serious felony allegations, ma'am. Court considers the information provided by your attorney as well as Madam Prosecutor. It appears you have ties to the community. No criminal convictions or cases history the court's aware of. The court considers the information alleged investigators report as well as the current epidemic facing the nation and the information provided by your counsel. And for those reasons, Ms. Amerson, your bond is set $10,000 personal bond. And again, you have a probable cause hearing January the 6th of 2021 in front of Judge Giles at the 36th District Court. Anything further, Madam Prosecutor?
No, Your Honor.
Defense. Thank you. Have a nice day, ma'am, and be safe. Good luck, Miss Amerson.
Thank you, sir.
Thank you, Judge.
Thank you, Ms. Tuzar. Anything further, or is that, or those the two that you were here on?
That was Your Honor. Thank you.
Okay, thank you. Be safe and have a nice evening.
You too.
Yes, sir. See you tomorrow.
And then thank you, sir, for, is that all you have at Division 3?
Yes, correct.
I appreciate your assistance. Be safe and have a nice day.
Thank you, Judge.
Thank you. DDC, thank you, sir. I think everything else. We have one matter at 3 o'clock in MDOC. Besides that, we should be ready to go. Good afternoon. Your name, please.
Edward Mensa, sir.
Good afternoon, Mr. Mensa.
Yes, sir.
We're here for case 200459448, People State of Michigan versus Edward Mensa. Brother Counsel.
Yes, John Brandenburg, on behalf of Edward Milton, my client, waive the right to formal reading, understand the constitutional right to stand reading.
For a waive formal reading in her plea of not guilty. Get to the court date in a moment, Esteban.
Fine, now, my client in the case was that he is a 29-year-old resident of Michigan for the past 7 years. He also in the case is that he has no prior criminal conviction. He's never been no probation and parole. He understands the issue. No confidence in the law. I understand that he has 2 children. Respectfully, I understand that these are false allegations now, but, plan for vigorously defend his position, and respectfully ask the court potentially for personal bond or reasonable bonds, reasonable 10% bonds, and this type of court.
Thank you, counsel. Mr. Mensah, the court scheduling a pretrial date, sir, that you must attend on January the 4th. That's at 8:30 a.m. 36th District Court in front of Judge Garrett. That hearing, Mr. Mensah, will take place via Zoom, which is, thank you, off-site streaming technology. You'll get information on how to connect for that Zoom hearing before you're released. But, sir, it is your responsibility to connect on time, understood?
Yes, sir, I understand.
Thank you, Mr. Mensah. The court considers, sir, the information provided by your attorney who has advocated well on your behalf. This is a very serious assaultive allegation, Mr. Mensah, but the court considers a number of things, including your ties to the community. The court's unaware of any criminal convictions or capious history in the past. The court considers the current epidemic facing the nation, as well as the information alleged investigators report in your employment status as it relates to the ability to post bond. This is a very serious, as stated, assaultive allegation, and the information alleged investigators report gives great concern regarding the safety of the alleged victim, Ms. Posey. During this bond, Mr. Mensah, you are not to purchase or possess a firearm or any other dangerous weapon. And do not go to the premises or area of 24235 West McNichols, Detroit, Michigan. Is that all clear?
Yes, sir, it is.
Thank you, Mr. Mensah. And you're not to have any contact with Latia Posey. That means no contact of any kind. No contact orally, in writing, through a third person at her place of residency, employment, or through any forms of social media. Absolutely no contact. Is that understood, Mr. Mensah?
Yes, sir.
Thank you. And given the information alleged in the investigators report outlining a serious alleged assault, the court will you'll be fit with the GPS tether prior to release on a $10,000 personal bond. You're being released on that personal bond, sir. No contact with Miss Posey. Make sure and make your Zoom hearing. Good luck.
Yes, sir. I get a tether?
You're welcome.
Did he say tether?
Tether, yes.
White line, first and last name.
Whoa, was that Edward Mensah? Could we bring back Edward Mensah? It looks like he has 2 cases that weren't rubber bands.
Hey, come on, man. White line, say your name again, brother.
Edward Mensah, sir.
Thank you, Mr. Mensah, and I apologize that you have another matter, and we're going to handle that matter right now, sir. And it's in case 200621999, People State of Michigan versus Edward Apoku Mensah, brother counsel.
Yes, Your Honor, Frank Bird on behalf of Edward Mensah, I'm trying to wait.
Court away formal reading under plea of not guilty. We'll get to the court dates in a moment as to bond. Sure.
Another charge, man? For what? What the hell?
Is that, Madam Clerk, is that Mr. Mensah's file? Can I just see it just 1 second? Thank you so much. Thank you. Thank you. As to bond counsel.
My client is a 29-year-old resident of Michigan for the past 7 years. Besides these allegations, we have starts school at 73, high school graduate, on probation, so understand there's no contact beyond two children, and understand that these are some allegations, but there are a couple things that concern me in the report. First of all, complaint that he was medical attention. Second of all,
What does that mean?
right, I'll say.
What does that mean? I have a question, but continue.
Hey, you might help me answer your question, you know.
I hope so.
No, it's the fact that there's no evidence of any scratches, and for the extent, as far as that report goes. No.
That's not accurate, though. There's a difference between evidence of scratches and refusing medical treatment.
Right, but I'm saying, if you had injury bad enough as the report states that
Your Honor?
in the dark. It seems that you would want to get medical attention.
And what are you getting at? I don't understand.
I'm getting at, there's a possibility that the plaintiff may not tell the truth about the story, you know?
Because you're alleging because she didn't want medical attention.
There's no evidence that shows that she told the truth about the story of her account of the story.
Okay, and this allegedly happened 3 days ago during the current pandemic. And so the court would understand why anybody would not want to go to a hospital at this point in time. But go ahead.
There's no other evidence, there's no other evidence that as she explained her account of the situation.
Okay, keep going, if anything.
Well, respectfully, I understand these are assault of allegations. And as you say right now, they are allegations, very little evidence to back it up. We respect that.
Thank you, Brother Counsel. Mr. Mensah, these are very serious assaultive allegations, and the court has concerns not only on these allegations, Mr. Mensah, but the court just handled another assaultive allegation prior to this matter, which occurred within a period of weeks. That both allegations, both assaultive allegations, both allegedly within the city of Detroit, both alleged against the same victim, Miss Posey. And that gives the court concern regarding that individual's safety, that we had
Yes, sir.
numerous assaultive allegations against the same victim, allegedly in the same, within a short period of time. Mr. Mensah, you can say anything you would like. I'd just like to give you a court dates. You have 2 court dates. You must attend them both. A probable cause conference Tuesday, December the 8th. You have a right to a preliminary examination the following Tuesday, December 15th. Both 8:30 a.m., 36th District Court in front of Judge Jones. As with the prior matter, Mr. Mensah, those 2 will take place via Zoom, which is an off-site streaming technology. You'll get information on how to connect, but it's your responsibility to connect on time. The court not only has concerns regarding the assaultive allegations, but takes into consideration your ties to the community, the current epidemic facing the nation, the information provided by your counsel, including but not limited to employment status as it relates to the ability to post bond. Court also takes into consideration the current epidemic facing the nation and the information alleged in the investigator's report. During this bond, Mr. Mensah, you are not to purchase or possess a firearm or any dangerous weapon. Absolutely no contact with Latia Posey, and that means no contact of any kind. No contact orally, in writing, through a third person, at her place of residency, employment, or through any forms of social media. No contact with Miss Posey. Is that clear?
Yes, sir.
And that includes at her residency. And if you're able to make bond, you're to be fit with the GPS tether, given the information stated on the record.
What is my bond, Your Honor?
Your bond, for the reason stated, is set
Can I speak, Your Honor?
5,000. Absolutely.
Please, Mr. Minister, please.
Yes, sir.
Attorney Freddie Bird speaking. Please do not go into the facts of this case. Please, brother. I'm trying to,
Yes, sir. Yes, sir.
get the best defense you can, so.
And that was your counsel speaking, and you are being recorded, sir. And I believe he's advising you to remain silent. But you take that advice for
Yes,
however
I
you'd like
do.
to take
Yes, I
it.
do.
So is there
Yes,
anything
I
you'd
do.
like to say?
No,
You're
sir.
remaining silent then? Okay. Mr. Mensa, for the reasons placed on the record, sir, your bond is 5,510%. Good luck, sir.
Wow.
Listen to the court. You're welcome. No
Wow.
contact with Miss Posey, okay, Mr. Mensa? That's $550. Any questions, sir?
She.
Please,
Um,
please.
the
Please, that's a question about mine.
I don't even.
If you have a question, go ahead.
The three cases that you guys speak of, the first one, she's the one that assaulted me, and she was the one put in jail.
Mr. Mensa, please.
Yes, sir. Yes, sir. I don't know what to say, but I just feel like I have been wrongfully ruled against. But God knows best. And yes, sir.
Listen to your counsel. This is, it's not a ruling, Mr. Mensa, as stated. It's a bond. In the court, you have two allegations of assault against, they're just allegations, and the court entered a not guilty plea on your behalf, sir. But the court has an obligation and a duty to protect the public. The allegations against you, Mr. Mensa, is that you allegedly assaulted the same young individual, same woman, on 2 different dates within a 2-week period, and they're very assaultive allegations. And so the court gave you a personal bond on one and what the court considers a nominal bond on the other. And so it's just very important you listen to the court, sir, make those court dates, refrain from any contact with Miss Posey, and there'll be an attorney, if you cannot afford one, to represent you at the next court date. Do you have anything else or any questions or anything?
My concern is I cannot afford the bond, sir, and I have a life out there that I have to take. I got a career that I got to worry about, Your Honor. I'm going to school right now in college, Your Honor.
Where are you in school?
In Wayne State College, Wayne State Community College.
You guys are going, you're currently enrolled?
Yes, sir, but I don't start yet. But
well, Mr. Mensa, then you're not enrolled. Or you may be enrolled, but you're not in school if you haven't started.
Yes, sir, but I have things I have to go take care of, which.
Well, good luck with that. I hope your school works out for you, Mr. Mensa, but you're not in school now, so I don't know where you're getting with that.
Mr. Mensa, you're gonna get a chance. You got a date coming up next Tuesday.
I can't afford to stay in jail.
We're gonna call the contact. You gave us the contact. We're gonna call them. We're trying to get to. We're trying to see if we can find a bond agency that might help you out. I can't promise you that. But at this moment, right now, speaking on the screen is not helping you at all.
Yes, sir. Thank you.
Good luck, Mr. Mensa, with everything, school and everything. Good luck. Thank you, Counsel.
Andrew Sanders.
Good afternoon, Mr. Sanders. Mr. Sanders, you're here before the court, sir, on case 200458882, People State of Michigan versus Andrew Sanders. Court waive formal reading in their plea of not guilty. Schedule a pretrial date, Mr. Sanders. You must attend January the 4th, 8:30 a.m., 36th District Court in front of Judge Garrett. That hearing, sir, will take place via Zoom. That's an off-site streaming technology. You'll get information on how to connect for that hearing before you're released, but it's your responsibility to connect on time. Do you understand?
I understand all of this, Your Honor. Can I ask you a question?
What's that? Not guilty, Senator. You can ask any question you want.
Okay. I'm already on probation for this, and they talking about a case. I just got through talking to the judge, and on Zoom, and my probation officer. And
what are you on probation for, sir? What are you on probation for?
This case.
What case do you think this is?
This is between me and Angela Coleman.
For what? Beating Angela Coleman?
No, for just domestic violence with Angela Coleman.
Madam,
that was,
I'm already on probation for another matter. Could you see if he's on probation for another matter?
No, that's the same.
One moment,
matter.
Mr. Sanders. We're going to check out that information that you provided, and thank you for that information.
That is through Judge Garrett's court.
Okay, Judge Garrett. Okay, thank you. One moment. His birthday is 3/27/57. Excuse me. Yes, absolutely. Could I get the printout of that? Thank you. Thank you. Okay, thank you, Madam Clerk. Appreciate you, both of you. Mr. Sanders, and the court's changing. Well, the court date may not be the same, Mr. Sanders, and the court is now aware that you do have an outstanding conviction that you are on probation, and this is a different. This is a conviction. It is for a domestic violence, sir, and it appears to be against the same individual. But this alleged. I don't know why you're shaking your head, Mr. Sanders. Why are you shaking your head?
Because I don't understand. Like I said, I'm on probation. I don't have any contract.
I'll tell you right now, Mr. Sanders. The one that you pled guilty to allegedly took place on or about January the 10th of 2020. The one that we are handling now allegedly took place April 22nd of 2020. That's over 3 months later. And so it's just an allegation, but the conviction, you are on probation, it appears for a conviction, which you were to have no contact. According to the.
I haven't had any contact with her. I haven't had any contact.
But we have a domestic violence allegation where it's an alleged not only had a contact, but it was assaultive contact in April. And you were sentenced on this matter.
Yes, sir.
You can always talk to your client, counsel, and can I talk to the defendant?
But Mr. Sanders, I will advise you right now to let us go through this arraignment. You exercise the right to remain silent. And at this point, you're doing yourself more harm than you're doing yourself good.
Okay, thank you.
Next lawyer will be able to work that out. You'll be able to work out what you need to work out and get all the facts together. But at this moment, we need to get you arraigned. And so you don't hurt yourself more than you help yourself. You need to exercise the right to remain silent.
Okay. And the court date, Mr. Sanders, is being changed. The court date is now December the 9th, which is Wednesday. December 9th, next Wednesday, 8:30 a.m., 36th District Court in front of Judge Garrett. Is that clear?
Clear.
Okay. And then that, as well with the last hearing that was scheduled, will take place via Zoom, Mr. Sanders. That's an off-site streaming technology. Your good information on how to connect. Anything further regarding Biden, Brother Counsel?
We're playing this case to he's a 60-year-old lifetime resident. Tired from home proof, working it down 40 years.
I've been 9 o'clock.
Especially now I understand talk about allegations. These allegations that my client won't being bigger. Especially in this court.
Thank you, counsel. Mr. Sanders, not only is this a very serious assaultive allegation, but you're, as stated by yourself, you're on probation for an assaultive conviction where it appears you pled guilty to domestic violence against the same victim that you allegedly have assaulted roughly 3 months later in the city of Detroit that we're here before this afternoon, Miss Angela Coleman. And not only did you allegedly assault her while it appears you had a pending assault case going against her, but you allegedly made threats against her life, including but not limited to that you were going to kill her and you wanted her to die. And that's including alleged assaultive actions that you took place on your part against Miss Coleman. So not only did you allegedly assault her, you allegedly threatened her life, and you're on probation, as stated by yourself, for a conviction against the same individual. That's all very concerning, and the court takes that into consideration, as well as your ties to the community, lack of capious history. The court's aware. The court considers employment status, as counsel stated, as relates to ability to post bond, as well as the current epidemic facing the nation. During this bond, Mr. Sanders, you are not to purchase or possess a firearm or any dangerous weapon. If you're able to make bond, you're to be fit with the GPS tether, given the presence of threats and the information that's been placed on the record. Do not go to the premises or area of 7601 East Jefferson. Is that understood? Detroit, Michigan, apartment 1205. Do not go to that premises or area. Is that clear?
That's clear.
Thank you, Mr. Sanders. And you're to have absolutely no contact with Angela LaShawn Coleman. No contact means no contact of any kind. No contact orally, in writing, through a third person at her place of residency, employment, or through any forms of social media. Absolutely no contact with Angela Coleman. Is that clear?
That's clear.
I haven't touched her. I haven't done anything. I stayed away. Every now and then, so let's see my face on Zoom or something like that.
And based on the information placed on the record, as well as information provided by yourself and reviewing the register of actions on your prior conviction and the information alleged in this matter, bond in this is set 8,010%. Good luck, Mr. Sanders.
This way, sir.
I'm brewing.
Hey, brother, we'll have some of that bench up there and put you up, sir.
You're welcome.
Master, prepare what files you have ready next, Your Honor.
Excuse me, sir?
What files do you have ready next, Your Honor?
Oh, thank you. We have all the files. It just depends on who's been interviewed. Brother Counsel's going to get the sheets right now. Just give him one moment, and he's coming back in with who's been interviewed.
Copy that.
Thank you, sir. Thank you both for giving me that information so quickly. Thanks.
Just get interviewed? Yeah, you gotta get
that guy, that one that we brought back. Thank you for your patience, officer. He should be back in just one moment. Thank you, sir.
He comes down here. Wait till he comes back down. Which one is that?
That's it. That's his name. Right. That's Clark.
So that one at 3 o'clock, what was that? What's up with that one? Are they supposed to call in? Or? Okay, he's walking back in. Thank you, sir. We have Andreas Clark, number 6. Yes, yeah. And a Devin Todd. Thank you, officer. And good afternoon, sir. Your name, please.
Andreas Clark.
Thank you, Mr. Clark. Good afternoon, sir. Mr. Clark, you're here for case 200622200, People State of Michigan versus Andreas Clark. Counsel.
Yes, ma'am. On behalf of Andreas Clark, I'm ready to write the formal reading. Right to the prayer meeting.
For a waive formal reading and I plead not guilty as to bond.
I'm planning the case young little case that he can no prior conviction, he never even been arrested. Now, what makes the world, he understands that he has no contact with the plaintiff. Financial responsibility was 1-year-old son, and doesn't work. And I understand that you got soft delegation now, but we step in.
Thank you, Brother Counsel. Mr. Clark, the court is entering a plea of not guilty, waiving formal reading and scheduling a pretrial date, sir. You must attend January 6th, 2021, 8:30 a.m., 36th District Court in front of Judge Archer. Mr. Clark, that hearing will take place via Zoom. Sir, that's an off-site streaming technology. Before you're released, you'll get information on how to connect for that hearing. But Mr. Clark, it's your responsibility to connect on time. Understood, sir?
Yes, sir.
Thank you. Mr. Clark, the court considers a number of things. Your attorneys advocated well on your behalf, and the court considers the information he provided, including but not limited to your employment status as it relates to ability to post bond. Oh, is it? Yep, sorry. Thank you. You're the best. Thank you. So, you are. Thank you. Mr. Clark, that's going to be a probable cause conference on January the 6th, 2021, okay? Probable cause conference. Same court date and time, but it's set for a different hearing. Probable cause conference. You must attend it, sir. It's going to be via Zoom. And the court's read and considered the information alleged in the investigator's report, which leans towards a likelihood of conviction, sir. It's indicated that the officers observed you shove the alleged victim. And the court notes that the court's unaware of any capious history or criminal convictions. These are very serious assaultive allegations, and the court does consider the current epidemic facing the nation. And for those reasons, Mr. Clark, you are not to purchase or possess a firearm or any dangerous weapon during this bond, and do not go to the premises or area. Mr. Clark, you live on Wayburn, is that correct?
Yes.
Does Miss...
She don't stay there. She has her own house.
Okay, I didn't even say anything, Mr. Clark. She stays on the road?
She stays in Taylor, Michigan.
Okay. So before I even ask my question, you answered it. So do you have absolutely no contact with Chantra Foreman? Is that understood? No contact during this bond. And that means no contact of any kind, sir. No contact orally, in writing, through a third person at her place of residency, wherever that may be, employment, or through any forms of social media. Absolutely no contact with Shatria Foreman. Is that understood?
Yes, sir.
Thank you. And for those reasons, sir, you're going to be released on a $10,000 personal bond. Good luck, Mr. Clark. I hope it works out for you, sir. No contact with Miss Foreman, and do not purchase or possess a firearm or any dangerous weapon, and make sure and attend the Zoom hearing on January the 6th. Understood?
Yes, sir.
Good luck. Okay. Oh, they need us to call on the, if you could write it down and just pass it to Madam Clerk, I'll call right after I finish this. Thank you, sir. Good afternoon. Your name, please.
Devon Todd.
Thank you, Mr. Todd. Good afternoon. Mr. Todd, were you here yesterday, sir?
Yes, I was.
Okay. This is case 200622201, People State of Michigan versus Devon Maurice Todd. Counsel. Thank you, Brother Counsel. Court waive formal reading under plea of not guilty. Mr. Todd, the court scheduling 2 court dates, sir. You must attend them both. A probable cause conference on December the 8th, which is Tuesday. You have a right to a preliminary examination the following Tuesday, December 15th. They're both at 8:30 a.m., 36th District Court in front of Judge Giles. Those hearings, Mr. Todd, will take place via Zoom. That's an off-site streaming technology. You'll get information on how to connect for those Zoom hearings, but it's your responsibility to connect on time. Do you understand?
Yes, sir.
Thank you. Not guilty is entered as the bond. Thank you, Brother Counsel. Mr. Todd, these are very serious allegations.
I understand that, sir.
What were you here for yesterday, Mr. Todd?
I was here yesterday for a warrant for fleeing and looting.
For fleeing and eluding. Thank you.
But it's
Mr. Todd. Go ahead.
Todd, with the seriousness of these allegations, brother, this is your attorney, Brandon Bird speaking. With the seriousness of these allegations, respectfully, I ask you to please exercise your right to remain to help you create the best defense that you can for yourself. At this point, it's not too much that we can do. You can just dig yourself and figure out.
I mean, it's Walker up front.
I didn't hear.
That was your counsel speaking, Mr. Todd. You can say what you like, but that was his recommendation. Mr. Todd, the court considers a number of things, sir. The court has read and considered the information alleged investigators report, the nature of these charges, which are very serious assaultive allegations. 4 of these allegations carry possibility of life in prison. The court notes you have ties to the community. The court's unaware of any CAPIAS history. The court does take into consideration your prior criminal convictions, which include assaultive convictions for armed robbery, and which give rise to the habitual offense, 4th offense, mandatory 25-year sentence. And the court takes consideration your prior criminal convictions, the epidemic facing the nation, as well as lack of employment status that counsel stated as relates to ability to post bond. Mr. Todd, during this bond, there's to be absolutely no driving. You are not to purchase or possess a firearm or any dangerous weapon. If you're able to make bond, you're to be fit with a GPS tether. And during this bond, Mr. Todd, there's absolutely no contact with Forrest Neal Sr., no contact with Forrest Neal Jr., no contact with Brittany Thomas, and no contact with Jada Neal. Mr. Todd, no contact means no contact of any kind. No contact orally, in writing, through a third person, at their place of residency, employment, or through any forms of social media. No contact with any of those individuals. Is that understood, sir?
Yes, I understand.
Thank you, Mr. Todd. Given the information placed on the record. Go ahead.
I understand I was trying to figure out about these charges. I really don't even know how to ask you this, but
If you don't know how to ask me, it might be best that you don't ask.
That was your attorney.
At this point, you might want to wait till you get to your next attorney.
That was your counsel, Mr. Todd. He asked, I believe, advised you to remain silent. Is that correct?
Correct.
Okay, so is there, but your call, sir, any questions or statements or anything before the court imposes bond? And your counsel's advised you to remain silent.
No.
For the reasons placed on the record, bond is set $250,000 cash surety. Good luck, Mr. Todd.
Huh?
DDC, if you could give us a moment, we're going to call Livingston, and they'll give an opportunity for counsel to interview the rest of the people. So we'll call you back in just one moment, if that's okay, sir.
That's fine.
Thank you, ma'am. We'll call you back in a moment. We just have one matter over there.
Just step on the line, folks. Tell me your name.
You gonna call them back in.
Your Honor, when we look at the Zoom password, what looks like a lowercase a is actually a Q.
Thank you. I don't know what I would have thought that is.
Sorry.
No, you're good. So I apologize. So it's not, the Zoom is just the Russie?
So, no, I'm sorry.
That's what I thought, that says pass.
Pass.
Oh, okay.
I gotta do that.
No, it's better than mine, I can tell you that. So pass, and then capital pass, and then a colon.
Yeah, that's just the password. The password starts with capital Z.
Okay, so what's the Zoom, sir?
It's the number right above.
Gotcha. With those dashes in it?
No.
Okay.
I didn't even do anything.
It says failed to call, brother counsel.
What's it say?
That's the Zoom, is the 2695?
Is the Zoom.
The 269?
Yeah.
That's the complete Zoom ID?
Yeah, it looks like the phone number, right?
Yeah, and it's not working. 269-588-2445. Did you use this?
Yeah, I did
And you zoomed with that? 269. 588. You want to come around here? So, this you put it in there just like that. 269
588 2445.
I tried it with and without the dashes.
Yeah, it gave it to me.
Is that to join a meeting though?
Yeah.
They can't
We're
call.
calling them. They said they can't call us. Dude, they weren't even, they were surprised to even hear from me. I don't even think they were prepared. I had to schedule a time from 3 to 4 for us to get them arranged.
I don't know. I think that's not working. Is it because I have a meeting and I'm trying to join them because I'm already the host on this and join in theirs? I don't know.
No idea.
They can't call into us?
They said they can't. I can bring my iPad out here if you want to. I don't know if something has to be streamed.
What about if can you call them from in there and I could
Yeah, I can try. I'm
on
gonna
the,
see
on
if
the
I can
computer with Mr. Reagan and then,
polycom zoom them. See if I can polycom zoom.
okay, and then if you can get it on the computer with Mr. Reagan, I could
Yep,
bring you in
breakout.
and a breakout.
Okay, let's try that.
Okay.
You want to keep that with you?
Well, I have it right here, and then I'll try to maybe call them while you're doing that. See what we can do. All right, thank you.
Thank you.
Do you think I should go back to DDC, or you want a couple minutes to figure this out real quick? Take your time. All right. Hi, Christy. Good afternoon. This is Magistrate Clerk at 36th District Court. How are you? I'm well, thank you. Yes, ma'am. Oh, it was scheduled at 3 o'clock, so nobody's been waiting and waiting and waiting and waiting. And you were right. Okay. Well, nobody called in to us, and you have no information on how to contact you guys, and so. Okay, I just tried. It's a phone number, that 269-588-2445, and it's not working right. And I'm putting that in the call out, and it's not working. So, right, it's not working. Why can't you guys zoom into us? Okay, great. Oh, it's great. They were told we couldn't, so I can give you the Zoom information and just call in, and we'll be ready. Oh, that's the best. Thank you so much. Okay, it's the Zoom information is 360-134-0000. Yep, they can zoom into us. And you've already interviewed them? Oh, you're great. Oh, perfect. Oh, thanks for your assistance. Yep, we're on the record right now, and I got the file in front of me. So as soon as you call that number, it'll pop up on my screen, and I'll accept. Yes, ma'am. And if you have any questions, you want me to give you the courtroom's number? Okay, it's 313. Oh, no, that's not good. I'll look into that. Is it 974? 965, I apologize. 2281. 965-2281. And that rings right to the courtroom. Okay, all right, so you'll be zooming in just a moment? Perfect. Thank you so much. Have a nice evening. Bye. Madam Clerk, she said, we're taking them away. She said, because we've been waiting and waiting and waiting and waiting and yet waiting all day for you guys to call and nobody called. I said, ma'am, it was scheduled at 3 o'clock and it's only 3:20.
She said 1 o'clock and I said no, 3 o'clock.
And she said, they're taken away. Then she said, I said, well, she's like, we've been waiting for you to Zoom. I said, why can't you Zoom us? We can. She's like, why, give me your Zoom number. And I said, well, I was just told you couldn't. She said, nobody told you guys that. She's like, we can Zoom you right now. No worries. No worries. I know. It might have been a different person, maybe. Who knows? That's impossible.
She told you that they couldn't? That's, yeah, because when I called before you came in here, and she told me the same thing.
Okay. That's okay. They said they can do it, so we're on the record. They'll maybe give you guys the rest of the time to interview these last couple of people at DDC regardless. We're back on the record. What's that, Council? Okay. No, you're fine.
Right. Okay, you're right. Yeah. No, you're not. No, you're not. Look at you. No,
We gave them the 360134, all zeros? Okay. Oh, you're there. Good afternoon, sir.
There you go.
Thank you, officer. I appreciate you.
No problem, sir.
Good afternoon, Your Honor.
Good afternoon. Could you state your name, please?
Contreras Henry, Your Honor.
Thank you. Good afternoon, sir. You're here for case 200-61743, People State of Michigan versus Henry Contreras. Brother Counsel.
Prior to on behalf of Mr. Contreras Henry, with formal readings and you, also Mr. Henry Contreras, standing by you, he's been advised his constitutional rights, Your Honor.
Thank you, sir. Mr. Contreras, the court's waive and formal reading under plea of not guilty. Scheduling 2 court dates, sir. You must attend them both. Probable cause conference is scheduled Tuesday, December the 8th. You have a right to a preliminary examination the following Tuesday, December the 15th. Both 8:30 a.m., 36th District Court in front of Judge Giles. Sir, both of those hearings will take place via Zoom. That's an off-site streaming technology. You'll get information on how to connect, but it is your responsibility to connect on time. Not guilty's entered. Esteban.
Esteban, Your Honor, I'd like this court to know Mr. Henry is 38 years old. He's a lifetime resident here in the city of Detroit, and he maintains he has absolutely no prior criminal conviction. I'm not aware of any cases history either, Your Honor. Once this court's developed, the last 25 years, he's been working at the same family-owned business. It's called Harold's Janitor Service. He's earned his GED here in the community, which is not before order. Your Honor, once this court's developed, he's not listed for building. But at this time, before his incarceration, Your Honor, he was residing with his wife and 4 of their children, ages ranging from 14 years old to 8 years old. Your Honor, I'm not prepared to discuss the allegations today. I understand that they're extremely assaultive. Given Mr. Henry's lack of any criminal or case history and his family ties and community ties, Your Honor, I've asked this court for a reasonable amount of personal bond.
Thank you, Brother Counsel. Mr. Contreras, your counsel has advocated very well on your behalf, and the court takes into consideration the information he provided, including but not limited to lack of criminal convictions the court's aware of. The court's unaware of any capious history. The court takes into consideration you have appears ties to the community, as well as the court considers employment status as stated by counsel's relates to ability to post bond and the current epidemic facing the nation. And officer, please mark Mr. Contreras filed medical for the reasons stated by counsel. The court's also reviewed and considered the information alleged in the investigator's report, which includes a presence of threats against individuals' life, as well as assaultive allegations and natures that give rise to the concern of the public at whole. Mr. Contreras, during this bond, you are not to purchase or possess a firearm or any dangerous weapon, and absolutely no contact with Malia McCrae Howe, MACRAE-HOUGH, and absolutely no contact with Langston Crawford. No contact means no contact of any kind. No contact orally, in writing, through a third person, at their place of residency, employment, or through any forms of social media. Absolutely no contact. Is that understood?
Yes, Your Honor.
Thank you, sir. And you are, as stated, not to purchase or possess a firearm or any dangerous weapon. Given the nature of these allegations, which are very serious charges, as well as the information, specifically counts 1 and 2, which both carry possibilities of life, as well as the information that's been placed on the record and stated throughout the investigator's report. Bond on this matter. And what was his employment status? He's unemployed, you stated?
Right now, he's unemployed, Your Honor, because he's been incarcerated since November 10th. But prior to his incarceration, he's been at the Girls Janitor Service. As of now, I do not believe he has any income.
Thank you. What are you locked up for, sir?
I guess robbery.
On this case, or are these allegations, or on a separate allegation?
On these allegations, but my lawyer told me to stand mute.
I understood, Mr. Catraz. You don't have to say anything. These are just allegations, and the court entered a not guilty plea for you. I appreciate that. For the reasons placed on the record, the nature of these charges, as well as the information alleged in the investigator's report, bond will be set. And given the presence of threats, $200,000 cash surety. I appreciate the request. The court started with a 10% or a personal bond, and the court feels comfortable with the cash surety has placed. The court has placed a tether as a condition of bond. There was not only, as stated, threats on individuals' lives, which gives concern to the court, as well as the nature of these charges and the information alleged in the investigator's report, which is including but not limited to likelihood of conviction, which it indicates allegedly, amongst other things, officers indicated that under a Facebook name of the victim or the defendant, the following day after these allegations took place, he was quote allegedly bragging about stealing an individual's vehicle. He was also picked out of a photo identification from a number of people, from an individual as identified as the person who robbed and took property. Also, it's very concerning regarding other information that also leads towards the likelihood of conviction. And so the court feels comfortable for the reasons stated.
Thank you, Ron. We appreciate the court's consideration.
Thank you, counsel. Good luck, Mr. Catraz. Anything further, counsel? Anything further, sir?
I don't even know what to say. Will I be going on tether?
If you're able to make bond, yes, sir, you have a tether fit. Any other questions?
Sir, bond is going to be subject to review at any time. At this point, this is your first arraignment. Counsel does have the ability to put in motions to address the bond at a later date. And I believe when you meet with counsel, that's something that you should request. Okay, sir?
And that was your attorney speaking, Mr. Catraz. Anything further? Any other questions, sir?
I couldn't hear.
He stated, I believe, and correct me if I'm wrong, counsel. He stated that bond is reviewable at every stage of the proceedings, and he's asking you to bring that to your attorney's attention and ask them to review bond, if appropriate, at the next stage. Is that correct, counsel?
That is correct. You're going to see another judge, and you'd have the opportunity to address bond at that stage, sir.
Anything further, Mr. Catraz? Thank you.
Do I have to pay a bond, or am I going to get released on tether? I don't know what's going on.
Your bond is $200,000 cash or surety. If you're able to make bond, you're to be fit with a tether.
Still breaking up.
Your bond, can you hear me okay now?
I can't.
Your bond, Mr. Caltraz, is $200,000 cash or surety. If you're able to make bond, You're fit with the GPS tether.
$1,000?
200,000. 200,000 cash surety. Absolutely, yes.
How? I can't pay no $200,000, and I can't even hear you, Your Honor, because the microphone is going in and out.
Okay. Do you have any other questions?
Am I going home on teller or something? I don't know. I can't hear you.
If you can make bond, I can hear you fine. If you can make bond, you'll be fit with a tether. Your bond is 200,000 cash surety. Your two court dates are December the 8th and December 15th via Zoom, 8:30 in front of Judge Giles at the 36th District Court.
Going in and out, sir. So you said if I come up with $200,000, I could go home on a teller?
Yes.
Oh, well, I can't come up with no $200,000. Okay.
And your counsel indicated that you were unemployed at the time, and the court
So I'm
took your
gonna just be
unemployment.
here until my next court date?
Your next court date is December the 8th. And bond is reviewable at every stage of the proceedings. You could ask the judge to address bond at the next court date as well if you choose to do so.
So what about teller? I gotta pay a
If you
bond
make
to get on teller?
You've stated that 2 times at least, and that is correct. If you make bond, you'll be fit with a tether. Yes.
Oh, well, I can't make no bond, so I guess I'm gonna just have to stay here till my court dates.
Anything further, Mr. Keltraz?
My next court date is December 8th.
I appreciate the attention. Yes, sir. Thank you for paying attention. That's it. December the 8th on a Tuesday.
So what happened on December 8th?
It's a probable cause conference. You'll have an attorney appointed to you at that court date to represent you if you cannot afford an attorney.
So what happened? What's going to happen on the 15th?
It's a probable cause. It's a preliminary examination. You'll also have an attorney appointed to you if you cannot afford one.
Okay. So basically, I'm gonna be here until the 15th, right?
I don't know. I mean, that's up to you and the bond and everything you got going on in your life. I don't know how you're going to proceed, sir.
Oh, but I can't come up with no $200,000.
So, sir, remember, and so just so we're not circular, Mr. Henry, when you get to the part of that next judge, you're gonna have another attorney who's gonna have the ability to put a motion in to reduce the bond. But at this stage, the magistrate has determined that your bond is gonna be set at 200,000 cash surety.
No,
No, I asked for a 10%, my motion was denied, sir. So you're gonna be before a judge at that next court date on the 8th, where your next attorney will ask another judge for a bond reduction.
Good luck, Mr. Keltraz.
Thank you, Your Honor, nothing further.
Thank you. Good luck, sir.
All right.
All right.
Can I be able to speak back to my lawyer?
Counsel, could you call him back?
I can, but Your Honor, I have to finish the record.
Okay, he said as soon as he gets an opportunity, he'll try to reach you back. Is that correct, counsel?
Yes.
All right, good luck, sir.
All right.
Thanks for your patience, officer. Thank you, sir. You guys are great. I appreciate you.
All right, I like that. I like that. I got one guy still to be interviewed, I believe, Willie Jacobs, sir.
Thank you, and defense counsel's copying that. He's going to take care of that, sir.
Thank you.
Thank you, bro.
You ready for some fun, sir?
Yes, thank you. Keep that out. I want to see that. Okay. Good afternoon. Your name, please?
Artemio Folk.
Are you a junior, sir?
Yes.
Okay, one moment. Your attorney's grabbing some information to help represent you. Thank you. Thank you. Okay, Mr. And your name one more time, sir?
Artemio Folk.
Thank you. And Mr. Folks, this is case. Oh, so your attorney stepped out again. Mr. Folks, you're here for case 2006138, People State of Michigan versus Artemio Folks, brother counsel. No problem. Yes, sir. We'll start from the top. Mr. Folks, third time, your name, please.
Artemio Folk.
Thanks. And first, we're handling case 2006138, People State of Michigan versus Artemio Folks, brother counsel. Thank you, brother counsel. Court waive formal reading and our plea of not guilty. Mr. Folks, the court scheduling 2 court dates, sir. You must attend them both. Probable cause conference on Tuesday, December the 8th. You have a right to a preliminary examination the following Tuesday, December 15th. Both at 8:30 a.m., 36th District Court in front of Judge Jones. Both of those hearings, Mr. Folks, will take place via Zoom, which is an off-site streaming technology. If you're able to make bond before you release, you'll get information on how to connect, but it's your responsibility to connect on time. Not guilty entered as to bond.
I just want to point out that he is on probation for this matter is on probation for since back to last year. So what happened, Your Honor, he was successfully on probation. And in May of this year, there were some allegations made. Okay, in May of this year. Now, what happened was he kept going back to court for his probation. And every time they brought up the new allegation, they said, hey, your allegations, they kept returning it. No charges were brought. Mr. Folks says that these are absolutely ridiculous charges. There was some type of animosity against him. But for 5-6 months, he kept going back to court with the CCW, and he kept returning it because nobody came forward with any allegations. And all of a sudden, in October of this year, like 5-6 months later, Judge, they actually signed a warrant. Now, when this allegedly happened, they didn't want to sign a warrant. They waited 5 months.
Well, I mean, who are you talking about? Who didn't want to sign it?
Well, it wasn't signed. That's what I said they didn't want to sign it. Let me speak.
And when was it submitted?
Judge, I don't know when
right. Yeah, so I don't know. It allegedly occurred May 24th of 2020 at 9:47 a.m. Right, and at that time, counsel is well aware that the investigation takes place on certain cases.
Absolutely.
And so, somebody not. Well, you stated that somebody refused or did not want to sign it, and I just want to.
Let me be clear. I'm not saying that no one wanted to sign it. I apologize. I don't want to dispute that. I just want to say, just to me, it seems that it's an allegation of CSC. That's very simple. You did it or you didn't. You can sign a warrant. Well, I'm sorry, the prosecutor process everything. I should say, not sign a warrant. The prosecutor can present that warrant, and the prosecutor, I don't believe, presented a warrant until October. It was actually signed, Judge, 6 months later. So I just wanted the court to kind of look at that as a basis. I know the CSC is a very serious charge. Mr. Folks said he's fighting this case vehemently. He's denying these allegations. And I just wanted the court to know that Judge gainfully employed, high school graduate. But I wanted to be forthright about his probation, Judge, with CCW, because I think that directly affects. They violated him because of his allegations back in May. He's been going back and forth for 6 months and they keep returning.
back, they adjourned this violation here, and now he's back in court last week. They adjourned it until April of 2021. So I just want to point that out, Judge, but again, I'm asking the court for some type of reasonable bond in this matter, and just, you know, I'm looking at the time frame, Judge, and I know it takes time sometimes for investigation.
I understand your argument. I appreciate that. And brief clarification, you said over 6 months, it was less than 5 months, but there is a period of time that there was some investigation or something taking place, and I understand what your argument is, and the court takes it into consideration. I apologize. Anything further, counsel?
Nothing on that, Judge. Ask for reasonable bond that person.
Thank you, brother counsel. Mr. Folks, as always, your attorney has advocated very well on your behalf, and the court takes into consideration the information he provided. Mr. Folks, this is a very serious assaultive allegation. You're on probation for another felony case. And unrelated, you have a capious history on another case we're about to handle where you failed to appear to court. And that's not on the case that you're convicted of, and it's not on this matter. That's a third pending case that court is aware of. And you failed to appear on that matter, Mr. Folks Jr., and that concerns the court regarding your intention to appear and handle this matter as ordered. The court's heard arguments from counsel that you've repeatedly made other court dates, and the court takes that into consideration, but has concerns that you've demonstrated a capious history on an unrelated matter we're handling next. And that's something the court takes into consideration. Excuse me, sir?
I made it to that court. You talking about for the telephone? They supposed to dismiss that. I'm not going for Judge Bryant.
It's a pretrial, not a review.
I'm sorry, pretrial for Judge Bryant. Judge, it was a via Zoom. I don't know. I think the Stevenson had ended up adjourning the matter, Judge, for some reason. He got capious, and I believe it was in October of this year. It was a capious, Your Honor, but previously he had a personal bond, and they were doing this via Zoom, Judge. And I'm not sure if he got days back with you, because I know he was making every court date for his probation case. Judge Clyburn. And I need to speak with Ms. Stevenson on this case. I think he was under the impression this matter was going to be dismissed. But again, Judge, until they actually this dismissal paperwork, I understand the court position. And I think Mr. Post was under the impression this matter was being dismissed. He appeared in every other case, Judge, with the CCW. So he's not a person that doesn't want to appear in court. Wants to appear before. I know Mr. Post again works in school board of bank, he's been doing so, and wants to appear before. He's not trying to avoid it. He has family ties to the community, Judge, and he wants to make these Zoom hearings as much as possible.
Thank you, counsel. Mr. Folks, and also the court takes into consideration what your counsel's been providing the court the information as your ties to the community. And the court considers the current epidemic facing the nation, as well as the nature of these charges, which are extremely serious assaultive allegations. Any information alleged in the investigator's report, which alleges, amongst other things, that you sexually assaulted a young 15-year-old female, which allegedly, according to the victim.
I started trial for that in April, sir. I just left court November 26th. I just left court for that November 26th. I started trial in April. I just reported.
Not on this, you don't.
Yes, for the CSC. For the criminal.
Do you have another CSC?
No,
Well, we'll check that out. Madam Clerk, can we look? Because this one, you haven't seen anybody on this.
What happened was they kept holding this case over his head because he's supposed to get off probation, Your Honor, for the CCW.
Was that non-public?
But they would not let him off probation because of these pending, because of the allegations. So this CSC case has been following him.
Right.
Because every time he goes to probation.
But to be clear, Mr. Folks, you've not been to court on this allegation of this criminal sexual conduct.
I've been back and forth to court since May. I've been back and forth to court since May. I put that on my kids on Jesus Christ.
Not on criminals, not on this charge, not on this charge. Understood.
No, I've been back and forth on that, sir, on the criminal sexual case. The CCW case, I haven't been to court in almost 2 years. I pleaded guilty to that a long time ago. The case that I'm on trial for, that I'm going back and forth for, is the criminal sexual case. I was just here for it. I left here, went to Dickerson. Dickerson released me. I went to court 2 weeks later. I started going back and forth to court every 2 weeks. She just gave me April 13th when I went November 24th.
It's not that number. Okay, well, Mr. Folks, this warrant, as Brother Counsel has indicated, was just signed on October the 20th of 2020. And the court has no information that you've been back and forth on this case at all.
Excuse me, sir. All you have to do is contact my probation officer or my judge. The judge will tell you I just left court November 24th. I promise you. If she tell you I ain't leave court, I will go back in the cell myself right now, sir. I just left court.
I believe you were in court on the 24th, sir, but not for this matter, is what I'm telling you. Not on this, it does not appear.
Listen, my CCW case is it's a purchased pistol without a license. I plead guilty for a 98 misdemeanor. They gave me 2-year probation. The only thing that I'm going to court for now is the sexual assault case. Nothing else. And I told him I wanted the trial. She told us we'll be back April 13th.
Well, Madam Clerk, both of the clerks are attempting to find that in the system, sir, and there's nothing in the system indicating that. And this warrant was just signed on October the 20th, so I don't know if you could make it to a trial date by November, being the fact.
Sir, my attorney just pulled it up for me, sir.
What's that?
My attorney just pulled up my judge's name, all the information. He said he just told me that he seen it in the system. I just left.
Okay. So, Mr. Folks, on this matter, sir, there's 2 court dates scheduled, December the 8th and December the 15th, both 8:30 via Zoom in front of Judge Jones. Is that understood? December 8th is your probable cause conference. December 15th is your preliminary examination, both 8:30 via Zoom in front of Judge Jones. Understood?
Yes, sir.
Thank you. And Mr. Folks, as stated, the court considers the information provided by counsel, the information placed on the record, your KPS history, and the information that's been surrounded and given to the court by yourself and the counsel, your current ties to the community, the epidemic facing the nation, as well as employment status as counsel states relates to diligent post bond.
I got a question,
well,
sir.
Give me a moment. And Mr. Folks, I'll answer your question. Just give me a moment, sir. I'll answer whatever question you have, sir.
Sorry about that.
And Mr. Folks, the very concerning is the information alleged in the investigator's report that, as stated, you allegedly sexually assaulted a 15-year-old child, where it's alleged that not only the complainant indicated that she was in pain, but also she alleged, sir, that you put a green and white pillow over her mouth so no one could hear her scream for help. And there's also other information that's alleged in the investigator's report that is very concerning. And it does appear that the complainant was taken to St. John's Hospital for a medical examination and rape kit. During this bond, Mr. Folks, during this bond, you are not to purchase or, Mr. Folks, I'll let you ask a question, but you're going to have to let me finish, sir. During this bond, you are not to purchase or possess a firearm or any dangerous weapon. If you're able to make bond, you're to be fit with the GPS tether. And during this bond, absolutely no contact with Honesty Greer. No contact means no contact of any kind. No contact orally, in writing, through a third person, at her place of residency, employment, or through any forms of social media. Absolutely no contact with Miss Greer. Is that understood?
Yes, sir.
And okay, do you have any statements or questions before bond is imposed?
I want to know how I'm getting charged this twice. Can you just contact my judge, sir?
Who's your judge?
He just told you. It's Darnella Claiborne. I promise you, I just left her courtroom, sir. I wouldn't lie to you. You finna charge me with something twice. That's what I'm trying to tell you. I'm not lying to you, sir.
Okay, Mr. Folks, and the information, the only thing I can go by is the information before the court. The information before the court is you've never been arraigned on this matter. And excuse me, and any information that Madam Clerk have both looked into the system, and there's no additional information that this matter's been arraigned. If sir, this is a second charge, then that can be addressed at the probable cause conference or the preliminary examination if you have paperwork indicating such. And I understand what you're saying, Mr. Folks, but I'm telling you, we don't have that same information. The court's information, it appears, is different. So if you have that information, what's that?
The police took my phone, so I can't get no information.
Okay.
I've been to court 9 times already, sir. Literally 9 times.
And counsel, do you have any information to present to the court regarding that this is the same case? I understand he's been to court, but he also has pending matters. He's on probation for a felony. He has a KPS history on an unrelated matter, and he has this pending matter. So, of course, he's been to court. I'm aware of at least 3 different cases that he's got going on. My question is has he been to court that you're aware of on this matter?
That's the only thing I'm going to court for.
When the people in this matter overstated, but not arraignment, not actual arraignment.
Right.
People use it
So he hasn't been to court on this matter.
based on what you have in your hand, but,
Do you have any information to the?
I don't, Judge. He said he has it in his phone, so I'm gonna wait to try to get his phone. He says he has that information.
And if he has it, I'm sure that could be easily resolved at the next hearing, hopefully. But Mr. Folks, your counsel doesn't have any information regarding this is in a prior arraignment. The court doesn't have any information, and it's not in the system, and it's not in the court file. So I appreciate what you're saying to the court, but I'm just telling you, we don't have the same information. And so, Mr. Folks, if you're able to make bond, you're to be fit with the GPS tether and no contact with Ms. Greer. Anything else before bond?
How do I got to do all this? You charging me twice for something, sir? Is y'all,
Okay. I've answered that question a couple of times, Mr. Folks. The court's not aware that this is a second charge for the same allegation. Anything further, Mr. Folks?
I promise you it is, sir. All right,
I'm just telling you we don't have the information.
Double jeopardy, real. I'm saying. But you can go and get my bond,
Mr.
Can't charge me something twice, never have.
Mr. Folks, I gave you an opportunity to speak. Please let the court speak. And given the information placed on the record and the serious nature of this charge, as well as the capious history and the current epidemic facing the nation, bond will be set. $40,000, 10%. Stand by, Mr. Folks. You have an additional matter, sir.
Sir, can you just contact my judge, please? Can you
Your
just
attorney
contact my judge,
can
please?
contact your judge.
But you trying to give me a high bond, and I already paid bond. I just paid probation yesterday. I just paid my court costs yesterday for Darnella Claiborne. I'll pay her court costs.
Her court costs? You
Yes,
don't have
I'll
any
pay
court costs
Darnella
on this
Claiborne. Can you please just call Darnella Claiborne, please, sir? She gonna tell you.
Your counsel
Please,
here.
I'm
If counsel wants to make any phone calls, the court will
Can you
listen to
please
any
tell me
phone
just
calls
call,
counsel.
Please. Please, sir.
Put your mask on, man.
Please, I'm begging.
Okay, your attorney is going to speak with you after this arraignment. Officer, if you could just put him on camera too. Your attorney wants to speak with you, and Mr. Folks Jr., your attorney can make whatever phone call they want to make, and I'll listen to any information that they bring back to the court, okay? And he's going to talk to you after this arraignment's finished up. And if there's any information that you guys could gather, I'll recall the matter, and we can handle it at that point, okay?
Yes, sir.
Okay, and so Mr. Folks Jr., you have one additional matter. State your name, please. Junior?
Yes.
Thank you. And this is case 1904478, People State of Michigan versus Admedio Folks Jr. Brother Counsel.
Right around on behalf of Mr. Ardeneo Folks, Jr.
Thank you, sir. Court waive formal reading and plea of not guilty. On this matter, Mr. Folks Jr., the court is scheduling a pre-trial date you must attend on January the 4th, 2021. That's at 8:30 a.m., 36th District Court in front of Judge Bryant. That hearing as well, sir, will take place via Zoom, which is an off-site streaming technology. You'll get information on how to connect, but it's your responsibility to connect on time. Not guilty plea is entered as to bond. And this is a capious.
26 years old, lifetime resident here in the city of Detroit. Anything with Sweetwater Express, high school graduate, remember, we would be doing the same honor at Council District. Further, I do want to know that neglect of this ROA shows that that date is scheduled to not believe that Mr. Folks had notice of that date. That's the perspective.
Why do you make that assumption? Is that what he said, or are you just guessing?
No, Your Honor, because it says removed from calendar.
So how do you know he didn't get notice?
Because, Your Honor, it would say defendant failed to appear.
So you assume he didn't get notice? Yeah, I mean, did he say he didn't get notice? I mean, I don't want you just saying things that you don't know to be true, counsel.
Your Honor, I'm looking at this ROA.
Right.
And it says on November 17, 2020.
Right.
The date was removed from the calendar.
Okay, that means they changed the date.
I'm not aware if he didn't have notice.
Right, that's what I'm saying. You said he didn't have notice, and you don't know.
I'm not aware if he has notice.
Okay, right.
I can ask counsel later.
After they changed the date, they didn't give me no information, sir.
Okay, thank you.
And I would never, I'm not misrepresenting the court at all. I'm just looking at the SR1, I see a court date has changed, there's another court date scheduled.
The court changes dates and removes them from the calendar all the time, and my clerk sends out notice on every time. And so just the fact they move a court date does not mean they don't get notice. We send out notice on every day. Now, the fact that he indicated don't have notice and what you're telling me, the court takes that all into consideration. But simply for the fact that it's been removed from the calendar does absolutely not mean that notice was not sent out.
Your Honor, and for the record, I'm also the attorney in Judge Price's courtroom and have that issue.
Thank you, counsel. Thank you, brother counsel. Mr. Folks Jr., this is a capias, means that you allegedly failed to appear on October 8, 2020, and a judge issued a warrant for your arrest and placed it a bond. The courts listened to the information provided by your attorney as well as to yourself that the matter was changed and you never received notice. And so the court is inclined based on that information, sir. And also, sir, you've had a previous capias history on this on May 15th, 2019, where Judge King issued a warrant for your arrest for failing to appear for a final pretrial. And so you've had more than one capias on this.
I don't know about that, sir. I never heard about that.
Well, you failed to appear, and allegedly Judge King issued a warrant for your arrest May 15, 2019. And then a warrant was, you were given a new court date.
I ain't seen Judge King since 2018, 17.
Well, that's because you didn't maybe show up to court because you were assigned to him on May the 15th, 2019. Well, it doesn't appear you showed up to court. And this is a second capias history. But the court's inclined to give you another chance, Mr. Folks Jr., and you have a lot of reasons that you don't show up to court. And I'm telling you right now, there should be no reason that you don't show up on January the 4th, 20. Maybe because you're not, Mr. Folks, listen to the court. I'm trying to give you a court date.
Because by my first step.
Sir, let's just remain silent until the.
Because my first step, y'all finna charge me twice, sir. Can I just get time to call my judge, please? I'm begging you, sir.
So listen,
please.
So Mr. Folks, hey, Mr. Folks, let's calm down. We're gonna have you talk to counsel. You guys are gonna go over everything as soon as this is done. Can you please just let the magistrate set the bond amount so we can get more time?
Spend the night here for nothing, bro. I'm suing. I gotta spend the night here. I'm suing. Tell me.
Nothing further.
What's that, Mr. Folks Jr.? I hear you mumbling stuff, but could you speak up?
I want to tell about nothing, sir.
Mr. Folks Jr., the court does have authorization given by the judge to change capias bonds in relation to this type of allegation. It's a serious allegation. The court's considered the information provided by counsel, as well as the nature of these charges and the information alleged in investigators report. During this bond, you're not to purchase or possess a firearm or any dangerous weapon, and absolutely no contact with Georgita Anthony, Georita Anthony. No contact means no contact of any kind. No contact orally, in writing, through a third person, at their place of residency, employment, or through any forms of social media. Absolutely no contact with Georgita Anthony. Is that understood? Good. And also, based on your capias history on this matter, as well as the presence of threats alleged in the investigators report that's alleged, sir, you stated you're messing with a real crazy one. I will kill you. That's.
Oh, no. Let me just be quiet.
Sir, don't say anything. Trust me. Don't
yes, sir.
Based on that information, sir, and the information that's your prior capias history, which includes one in front of Judge King, the court is keeping a court date or changing the court date to December the 11th. That is at Friday, 8:30 a.m., 36th District Court in front of Judge Bryant. December the 11th, that is going to be via Zoom. And the bond will be set in the amount of the capias at the time, Judge Bryant, in the amount of 510%. That's $50, sir. No contact with Georgita Anthony, no weapons, and if you're able to make bond, you're to be fit with a GPS tether. Bond is 510%. Good luck, sir. And could you put him in front of camera 2, please, for the interview? Yes, sir. Thank you. Yes, sir.
Hold on, Mr. Jacobs still hasn't been interviewed yet, Your Honor.
Thank you for that information. Mr. Jacobs, we need interviewed. I use the KP estate. I'm sorry, I messed up the front of the file a little bit. What's that, Madam Clerk? What was that? Okay. Okay, and then this is and I use the KP estate. Thank you. We got one more mail left, Brother Counsel. Thank you. 2 females. Thank you, sir.
Perfect. I'll be waiting on that.
All right, appreciate you.
Shit show.
Did you hear that?
Willie Jacobs.
Thank you, Mr. Jacobs. Good afternoon, sir. This is case 20045A03, People State of Michigan versus Willie Lee Jacobs for the council. Court wait formal reading under plea of not guilty. Mr. Jacobs, the court scheduling a pretrial day, sir. You must attend January the 4th, 2021, sir. That's at 8:30 a.m., 36th District Court in front of Judge Bryant. Mr. Jacobs, that hearing will take place via Zoom. That's an off-site streaming technology. Before you're released, Mr. Jacobs, you'll get information on how to connect for that court hearing, but it's your responsibility to connect on time. Is that understood, sir?
Understood.
Thank you. Not guilty is entered as the bond.
I have the personal bond,
Thank you.
3 days, the DDC on the driving suspended license, case, Your Honor. You will return to court. I will display this judge. I would ask for approval.
Thank you, brother counsel. Mr. Jacobs, the court considers the information provided by counsel in nature of this charge, the epidemic facing the nation, as well as the information alleged in the investigator's report. Kurt is unaware of any capious history or criminal convictions. Mr. Jacobs' serious charge was non-assaultive. During this bond, there's to be no driving. Understood? No driving.
Gotcha.
And you're being released, Mr. Jacobs, on a $250 personal bond. Good luck, Mr. Jacobs. Make sure and attend that Zoom hearing, sir, and no driving.
For sure.
Thank you. Good luck. DDC will meet you on the female side.
Yes, sir.
Thank you, sir. Thank you. Thank you, both. I'm happy. So we don't have to bring them back. Thank you.
Hello, you the judge?
Good morning. Afternoon, I mean.
Are you the judge?
Who are you?
Regina Guthrie.
If you could come in front of the camera, please, ma'am.
Regina Guthrie.
Good afternoon. Good afternoon, Ms. Guthrie. I'm okay. How are you doing?
I'm fine, Your Honor.
You okay? Stand up there.
Yes, I'm fine.
Okay. All right. This is case 20062-196, People State of Michigan versus Regina Guthrie, Brother Counsel.
Brian Morado, we have Ms. Regina Guthrie. Ms. Guthrie has to advise the council.
Thank you, sir. Court will waive formal reading and her plea of not guilty, Ms. Guthrie, and the court is scheduling a probable cause conference, ma'am, that you must attend on January 6th, 2021, 8:30 a.m., 36th District Court in front of Judge Giles. That hearing, Ms. Guthrie, will take place via Zoom, which is an off-site streaming technology. Before you're released, you'll get information on how to connect for that hearing, but it's your responsibility to connect on time, understood?
I will be there.
I appreciate that, ma'am. Not guilty is entered. That's the bond, Brother Chris.
This company's 48 years old. She's a lifetime resident here in the city of Detroit. She came to employment at Randy's. She wants to know that she's protected by herself at this time. Old age, hospitalization,
Thank you, sir. Ms. Guthrie, this is a very serious felony allegation, ma'am. It's important you listen to the court and make that Zoom hearing on January 6th. And during this bond, you are not to purchase or possess a firearm or any dangerous weapons, taser included. Do you understand?
Yes, Your Honor.
And the court takes into consideration the information provided by counsel, your ties to the community. You have no capious history or criminal convictions the court's aware of. The court's read and taken into consideration the information alleged investigators report, as well as the current epidemic facing the nation and employment status, as counsel stated, as it relates to ability to post bond. For those reasons, ma'am, you're being released on a $5,000 personal bond. You don't have to post any money. Listen to the court and make sure to attend a Zoom hearing. No weapons. Good luck, Ms. Guthrie.
Thank you, Your Honor.
You're welcome, ma'am. Good afternoon. Your name, please.
Betty Lucille McKnight.
Good afternoon, Miss McKnight. Is that a hoodie on your head? Could you slide that back for us? There we go. Thank you, ma'am. Ms. McKnight, you're here for case 20062-198, People State of Michigan versus Betty Lisa McKnight, also known as Betty Lucille McKnight. Brother Counsel.
Brian Morado, we have Betty Lisa McKnight.
Thank you, sir. The court waive formal reading under plea of not guilty. We'll get to the court dates in a moment. As the bond, sir.
As the bond, Your Honor, McKnight, she's a 58-year-old lifetime resident here in the city of Detroit. She's retired at this time. She receives social security income. She's a high school graduate, Your Honor. She wants the court to know she takes up a 4 different medications. Well aware of this kind of those medications. She needs to be in a situation. Although I'm not prepared to discuss the facts of the underlying allegations, I'm more concerned with this man's age. That he is looking for her social distance situation on the jail. She is something that we want to society with this virus.
How old is she?
She's 58 years old.
Thank you.
I believe Ms. McKnight is somebody that us as a society have a duty to sort of take care of in this global health pandemic because of the inability to social distance, because of all the medication she takes. I'm unaware of how immunocompromised she exactly is, but I'd ask the court respectfully to consider a personal bond at this time. I know the court normally does not impose personal bond at this time, but if it does, it definitely follows the normal DPS. Now, there are many court to deviate from what it would normally do. I understand what the allegations are here, Your Honor, but I believe that if she were to be put with GPS, I have to be advised by my office that sometimes that may delay her release. I ask the court respectfully to consider deviating, given her ties to the community, Your Honor, her old age, and I respectfully ask the court for a personal bond.
Okay, counsel, I appreciate all the arguments. The court takes everything you say into consideration, but the court has concerns not only these assaultive allegations, but she's also had a prior conviction for an assaultive conviction, which is concerning to the court. And at this thing,
Ma'am, let's let the magistrate finish the bond conditions and the bond amount, and if you have any questions after, you'll have an opportunity. Okay?
and then the court also indicates there's a likelihood of conviction, indicating alleged investigators report that the defendant struck the victim in the head with a liquor bottle and the officers observed a golf ball-sized knot in the middle of his forehead. And though the officers observed a golf ball-sized knot in the middle of his forehead, allegedly, the individual refused medical treatment. Counsel.
You look at my face.
Or what happened with the allegations. I'm really concerned.
You insulted me first.
With Ms. McKnight
Look at my eye.
and her age.
And the court has concerns as well, counsel. So, but the court's not simply feels comfortable straight releasing with no tether on a personal bond. And so, counsel, the court's inclined to give a nominal bond with no tether, or the court will feel comfortable possibly with arguments with a personal bond on a tether. Counsel, what would you, what?
I have need to advocate on behalf of the personal bond.
Tell me you make my mind.
Maybe advocating for that. Nobody monitored.
They did not witness me, they did not witness him hit me. Look at my face.
Hey,
What
man,
was that?
I don't want you to say anything because I don't want anything to be used against you, Ms. McKnight.
Excuse me?
Okay. The court will change the court date. The court date is going to be January the 6th, 2020. January 6th, 2021. January 6th, 2021. 8:30 a.m. 36th District Court in front of Judge Archer. That hearing will take place via Zoom, Ms. McKnight. That's an off-site streaming technology. You'll get information on how to connect, but it's your responsibility to connect on time. The court has concerns regarding your prior criminal conviction, and the court's reviewed investigator's report has concerns regarding the nature of the allegations set forth therein. Given as court also takes in consideration information presented by counsel, the current epidemic facing the nation, employment status as counsel stated as relates to ability to post bond. During this bond, Ms. McKnight, you are not to purchase or possess a firearm or any dangerous weapon, and absolutely no use of alcohol, no marijuana, and no illegal controlled substances. Do you understand? And you have absolutely no contact with Eddie Blunt. That means no contact of any kind. No contact orally, in writing, through a third person at his place of residency, employment, or through any forms of social media. No contact with Eddie Blunt. Do you understand?
Yes, sir.
And do not go to the premises or area of 12150 Wayburn Street, Detroit, Michigan. That appears to be his residency. He does not live at that address? He does?
He lives at the Veteran Center.
Okay, so the court's striking that condition, Ms. McKnight, of not going to that location. But to be clear, there's to be no contact with Eddie Blunt of any kind. And if that's his residency, you are not to go back to that location if that's where he resides. Do you understand?
Sure, yes.
And based on your prior criminal convictions, as well as the nature of this allegation set forth in the investigator's report, you're to be fit with the GPS tether prior to release. Your bond is set in the amount $11,000 personal bond. You're welcome. Thank you. Anything? Good luck, Ms. McKnight. A personal, yes. Make sure to listen to the court. Attend your court date. Officers, any males or females at 48 hours that can't wait till tomorrow?
Oh, sir.
Thank you, officer. Have a nice day and be safe. Thank you.